Thank you for everyone for being here today. We have a couple items on our agenda. Before we get started, we'll have the clerk call the roll.
Senator Alvarado.
Here.
Senator Harper Angel. Senator McDaniel. Senator McGarvey. Senator Nemes. Senator Schroeder. Senator Southworth. Senator Storm. Senator Thayer. Senator Wheeler. Representative Blanton. Representative Bowling.
Here.
Representative Cantrell. Representative Decker. Representative Duplessis.
That's right.
Representative Fisher. Representative Flood. Representative Gooch.
Here.
Representative Graham.
Here.
Representative Heath.
Here.
Representative Heverin.
Present.
Representative Herron.
Here.
Representative Imes.
Here.
Representative Johnson.
Present.
Representative Cook.
Here.
Representative Derek Lewis. Representative Scott Lewis. Representative Maddox.
Here.
Representative Mentor. Representative Moser. Representative Nemes.
Here.
Representative Scott. Representative Smith.
Here.
Representative Stevenson. Representative Tate.
Present.
Representative Tipton.
Here.
Representative Upchurch.
Here.
Representative Weber.
Here.
Representative Wheatley. Representative Bratcher.
Here.
Representative Miller.
Present.
Senator Mills.
I'm here. And we do have a quorum, and we're duly constituted here during the interim to have this meeting. Just a couple things since it's our first meeting. Just want to remind everybody to, during the interim, ask your question. If you have questions of the folks testifying, just ask a direct question. We need to be respectful of everybody's time. People have schedules and travel time and things of that nature, so please ask direct questions if you can. We have a couple items on the agenda today. The first, if we'd like to have the folks from the Attorney General's office come forward. We all know that there's a substantial amount of money headed to our state from the opioid settlements that have been handled by the Attorney General's office, and we have three gentlemen here today to speak to this issue. Four, and if you don't mind, gentlemen, if you can introduce yourself, just go across the way and introduce yourself, and then the floor will be yours. Oh, Representative Graham is here. Oh, yes.
Thank you, Mr. Chairman. If you will, I'd like to, we lost a former colleagues of ours, Wilson Stone, this past week. And for those of us who served with him, he was a man who was a compassionate man. He strongly believed in public education. He had served on the Board of Education in Simpson County. He represented Simpson and Warren. And if we could, Mr. Chair, if we could have a moment of silence on behalf of Wilson Stone and his service not only to his community, but to the Commonwealth of Kentucky. Thank you.
Absolutely. Thank you. Thank you, Representative Graham, for pointing that out.
Thank you.
Gentlemen, the floor is yours.
Thank you, Mr. Chairman. I'm Vic Maddox. I'm the Deputy Attorney General.
Chris Lewis, I'm the Director of the Office of Consumer Protection. It looked like it was on. Sorry. Chris Lewis, I'm Director of the Office of Consumer Protection at the Attorney General's office.
My name's Brian Hubbard, and I am the Chair and Executive Director of the Kentucky Opioid Abatement Advisory Commission.
And I'm Blake Christopher. I'm the Deputy General Counsel. Thanks.
Mr. Chairman, we understand that the committee wanted to hear from our office concerning the status of the litigation and the settlement of the cases that we had brought against what were called the Big Three distributors and Johnson & Johnson's Janssen subsidiary. And I think we have a few slides. The first slide, I think it's slide number 3 actually, settled litigation, outlines those three cases. There were cases brought in various circuit courts around the state, one each against the three what's called the Big Three. These were the distributors of opioids across the country. McKesson Corporation, Cardinal Health, and AmerisourceBergen Drug Corporation. The other settlement is with Johnson & Johnson's Janssen subsidiary, which is actually a manufacturer of certain opioid products. The settlement, as you can see, is a total of $483 million to the Commonwealth. That's roughly 2.09% of the $26 billion total global settlement. That $26 billion includes about $1.6 billion for attorney's fees. The remainder is abatement funds that are distributed to the states according to a formula that was agreed upon by the multi-state plaintiffs, the attorney generals around the country. And that formula is a function of state population as well as the severity of the opioid crisis in a particular state. And so that's what Kentucky ended up with. And as you all know, in the 21 regular session, the legislature passed what was HB 427, now codified at KRS 15291 and 293. And that statute provides for the creation of what is called the Kentucky Opioid Abatement Commission. Brian Hubbard has been announced earlier this month as the director of that commission. The statute also provided for the funds to be divided on a 50-50 basis. Half of the money comes directly to the Commonwealth. The other half goes directly to the city and county governments. And as you all know, because of KRS 15293 sub 4 sub D, we have a statutory bar so that all claims brought by any local subdivision are barred and released with the effectiveness of the settlement. And that was critical to ensuring that Kentucky would receive the maximum amount of funds available under this settlement. But for that legislation, we would have been in a position of effectively negotiating with city and county governments to have them sign on to the settlement. And states that did not have such a statutory bar were then in a position of qualifying for various incentive payments depending on the level of participation that their states were able to get for their political subdivisions. So we believed, and I think the legislature believed, because the statute passed unanimously, that that was the appropriate course of action for the Commonwealth. And that's how we ended up with the 483, which again is the maximum amount available. Could we have the next slide, please? And as you can see there, the distributor payments are made over a number of years, and that's 18 years. The payments are initially due, the first payment was due April of this year. The second annual payment is actually due, I believe, July 15 of 2022. Each of those payments, roughly $16.5 million. So when the consent judgments are actually filed and the checks are delivered by what's called the Settlement Fund Administrator, which is an organization, maybe in Delaware. I know the Wilmington Trust is the trustee of these funds. Then those checks will come into the Commonwealth. The 50% is what the Commonwealth will get to the Treasury. The remaining 50% will go to the cities and counties according to what's called the negotiation metrics that represent the schedule that the plaintiffs who represented those cities and counties, their lawyers, and the state attorneys general across the country agreed to for the allocation of those funds. That is still a function of some calculation, I guess, because if a city or county gets less than $30,000 over the lifetime of the settlement, then their money then rolls up to the county that they are located in, and that's a calculation that has to be finalized before the final percentages for those numbers can be agreed to. Chris is going to talk a little bit more about the numbers, but I will just tell you that even before I was sworn into office after General Cameron was elected, Barry Dunn and I, my predecessor, were on the phone with our counterparts across the country trying to understand the terms and the conditions of these settlement proposals and whether they were a good proposition for the Commonwealth of Kentucky. I attended a settlement conference headed by Judge Polster, the federal judge who was administering the multi-district case in Cleveland. I attended that conference in late February of 2020, and largely as a result of that, I think the distributors and Johnson & Johnson ended up adding about $1.5 billion more to what they had previously proposed. And effectively at that conference, I think the broad terms of this settlement were completed. It took another year almost for the actual settlement to be finalized, in large part, I believe, because there were questions about attorney's fees and how large the attorney fee pool would be. Let me just point out in this settlement, Kentucky, the Commonwealth of Kentucky, we had outside counsel. We are not paying our lawyers a penny. One of the things that Chris and I did with Barry and General Cameron's help was to sort of renegotiate the contract with our outside counsel, which had lapsed. We reinitiated it in July of 2020, and that contract provided that our lawyers would not take anything from the funds that came to the Commonwealth of Kentucky. They are getting all of their funds from either the settlement fund that is part of this agreement that is administered by the Cleveland multi-state litigation, or now they'll get funds if they represent cities and counties from the backstop agreement that was enacted in the most recent session of the legislature. So we feel like that change in the contract saved the Commonwealth, I think it was $6 or $8 million, was if you applied the Model Procurement Act formula to what the lawyers would have received, then the contract that they now have that they're acting under for these settlements ended up sending about $6 or $8 million less to them. We have the exact number. I don't have it at my fingertips. So that we feel like that is again, saving the Commonwealth as much money as we possibly can. These settlements are about to be funded in Kentucky, and the numbers are here. Chris is going to talk a little bit more about what those numbers are and what the Commonwealth and the Opioid Commission can expect in the coming months.
Go back one, Brian. Sorry. One thing to point out on this, you'll notice that the numbers slowly increase and then decrease at the end. That's a function of those different tiers that Vic was referring to that we would have been faced with if we hadn't had the complete statutory bar. Other states will look different than this because they're not getting incentive A or they're not getting incentive B. Because Kentucky is getting the entire payment as a result of the statutory bar, these numbers reflect the full payment available in any given year. And on this one, you can see it'll be paid out over 18 years. The first payments will probably be together at this point. We thought we might have a payment in June. It's more likely going to be sometime in July that you'll see payments 1 and 2 come in together or very close together. And that'll pay out over time through the 18 years under the distributor agreement. If you can go to the next slide. Johnson & Johnson Janssen is structured a little differently. And one of the things that the statutory bar did for us there is that they had a clause that any state that had 100% representation would get all 4 payments of the first 4 years in their first payment. So that's what's represented, and you see the huge drop there to 20 million after that, and that's a result of we will get the first 4 payments up front. We won't see another dime out of Johnson & Johnson until 2025, and then it will pick up and go forward. But importantly, there isn't a reduction in the amount being paid because it's being paid early. We are receiving the full amount that would have been paid over those 4 years without a reduction for early payment. And this next slide just represents the combined totals of those 2 settlements in each year as to how they play out. And you'll see the grand total of $483,774,569 and change. And the 50% mark of that will be $241,887 and change over the 18 years. And this would be from these 2 combined settlements what you will see coming in to the Commonwealth, to the Abatement Commission, and to the cities and counties at the 50% level. Do you want to take us?
Sure. So this slide represents a summary of our pending litigation. You can see that we have cases in Fayette, Circuit, Franklin, Boone, and Madison County. I'm sorry, that's in the Delaware Bankruptcy Court. That was in Madison County. We also have a claim pending in the Purdue Bankruptcy proceeding in the Southern District of New York. And I'll give you a little bit about each of these cases. Teva Allergan is a case that we recently added Allergan as a defendant. Allergan acquired some of the product lines that Teva manufactured, and so they have liability, in our view, for those products. CVS is a new case that we filed in 2021. CVS and Walgreens obviously are pharmacies. They are responsible in many respects for a lot of the abuses in the distribution of opioids over the course of the years. In some cases, they are distributors. In some cases, they are dispensers. That case, CVS, is obviously fairly new, but it's one that we're pursuing, vigorously. The same with Walgreens. The Endo case, Endo is a manufacturer of pharmaceuticals. They have been settling some of their cases around the country, and they had some discovery issues in New York that caused them to fire their longtime counsel. And I think that their new counsel, which I believe is one of the largest firms in New York, seems to have adopted a settlement strategy. Mallinckrodt is a bankruptcy proceeding that is now final.
Yes.
Yeah, go ahead, Chris.
So Mallinckrodt was a little different for us when it went into bankruptcy. The states formed an ad hoc committee to represent the state's interest. Our office served as one of the lead states on that ad hoc committee, and we're involved all the way through in getting the plan confirmed and dealing with various motions and challenges to the plan. That was finalized last Friday, I believe, and we expect payment from that to start coming in sometime in the next 80 to 90 days. The Mallinckrodt settlement does have several options for Mallinckrodt to pay off. If they decide to pay off over the full 8 years, it'll be $2 to $3 million a year over the 8-year period for a total of $21.8 million. They have the option to settle early. If they take the emergence plus 1 year, the state will receive $15.3 million in that first year. If they decide to take emergence plus 1.5 years of settlement, the state will receive 15.9 over the 2 years that would take to have that happen.
And when you say emergence, Chris, you mean emergence from bankruptcy?
Emergence from bankruptcy.
Right. And then finally, the Purdue bankruptcy, that's a case that has been in the Southern District of New York. You all probably recall that the Commonwealth settled some litigation against Purdue Pharma in December of 2015, and that resulted in a $24 million settlement for the state. I think there was $3.5 million paid to outside counsel, and the remainder was paid in a $12 million lump sum, and there's $1.2 million that is paid every January, and I believe there's 2 remaining payments on that settlement. This settlement represents a settlement that we pursued in the bankruptcy of the Purdue Pharma company and their family, the Sackler family. Is that right? Yeah, Sackler family. And the Sacklers themselves are putting in several $billion. This represents, I believe, about $91 million to Kentucky, half of which will, of course, because of the operation of KRS 15293, half of which will go to the cities and counties directly. The funds represented in this proof of claim and the bankruptcy payout represent the costs of abatement going forward in Kentucky. So all of these dollars are pegged to damages and abatement costs that the Commonwealth could demonstrate from the date of the settlement in 2015 going forward. And that's why there's no release of those claims. I will say that at the moment, the Purdue bankruptcy case is in front of the Second Circuit Court of Appeals. There was a challenge to the approval of the plan in bankruptcy. Effectively, that plan involved releases of claims against the Sacklers personally, even though they were not parties to the bankruptcy. And the question before the Second Circuit is whether the bankruptcy code allows for such releases. We expect the Second Circuit to decide that case in the next 3 to 4 months. Our hope would certainly be by the end of the calendar year. And if that plan is approved and the district court's decision effectively is affirmed, then that settlement would be put into place in pretty short order, I think. With that, I think I will turn it over to, you're going to take this one, right? Is that, I'm sorry? Okay. Blake Christopher, who is our Deputy Director for Policy, and turn it over to him.
Thank you. So we've walked through the status of current pending litigation and then the settled Big Three and Johnson & Johnson, all of which, of course, begs the question what to do with the settlement dollars, right? And thanks to the work of you folks and General Cameron and our local and government partners, we have a plan for using those dollars, and that plan is in House Bill 427 from regular session 21, and then as amended by House Bill 92 in regular session 22. And as I'm sure most of you all know, that plan has a 50-50 split, where 50% of the settlement dollars will go directly to the local governments, with the other 50% coming to the Commonwealth. The Commonwealth's portion, as we've discussed, will go to the Opioid Abatement Advisory Commission to administer. Now, we have a sub-bullet there that just talks about how these dollars actually get to Kentucky. And so, generally speaking, when you saw those charts before, when those payments come in according to those schedules, they will go to the national administrator. The national administrator will then send 50% of the payment to the Commonwealth's Opioid Abatement Trust Fund. The other 50% will be split how many ever hundreds of ways, right, with checks immediately going out to the cities and counties according to their percentage. And so that will be at relatively no cost, right? That entire facilitation will be at relatively no cost to the Commonwealth, and all those checks will get sent out pretty automatically. As you all know, thanks to House Bill 427, all funds, whether they go to the local governments or to the Commission, must be spent for opioid abatement. there is, the one exception for the fees and costs that were associated with the lawsuits. But we have to spend these dollars on opioid abatement, or we risk the settlement itself. And then finally on this slide, local governments and recipients of commission funds must submit regular certifications of compliance. 427 provides for annual certification so that we just generally can keep up with this is what the money's being spent on, and it's definitely going toward opioid abatement. And just for you all's quick reference, these are the statutory references. I mentioned before that the commission will oversee the Commonwealth's 50% of settlement proceeds. Before I turn it over to Brian and talk about the commission, just generally speaking, there are 11 total members, 9 voting and 2 non-voting. The members will, after their initial staggered terms, serve 2-year terms. The non-voting members, which I believe who serve at the pleasure of the Senate President and Speaker of the House, it's my understanding that Representative Bentley has been appointed to serve on behalf of the Speaker, and Karen Kelly will serve on behalf of the Senate President. Those folks will serve at the pleasure of their appointing authorities. And for more information about the commission and who will be serving, I'll turn it back over to Brian.
Thank you, Blake. There are 5 individuals who have been appointed directly by General Cameron to serve on this 11-member panel.
Could you pull your mic up closer? There you go.
How's that? All right, very good. There are 5 commission members who've been directly appointed by General Cameron, and they are Dr. Jason Roop of Campbellsville, representing victims of the opioid crisis, Van Ingram, who is the director of the Office of Drug Policy, I believe, representing the drug treatment and prevention community, Vic Brown of London, who serves on the HIDA Task Force, representing law enforcement, Vaughn Purdy of Louisville, Kentucky, with, I believe, Simmons College, is representing citizens at large. And then Karen Butcher of Georgetown is also a representative of citizens at large. And I am the Attorney General's designee as director of the commission. Those who have been statutorily designated include Treasurer Allison Ball. As previously mentioned by Blake, Representative Danny Bentley of Russell has been appointed by the Speaker of the House as a non-voting member, as has Karen Kelly of Somerset, appointed by President of the Senate. And then we have Dr. Sharon Walsh, who is the lead investigator with UK's Healing Communities Study Team, and then CHFS Secretary Eric Friedlander. The outlook for 2022 and 2023, our timeline is to begin meetings in the late summer and move into the fall to take place in locations throughout the state. The very first meetings will address drafting and publishing regulations, and KRS 15291 will allow the Commission to issue emergency regulations as the need may arise. We expect to have an online application process for those who wish to be considered for grants for abatement activity toward the end of 2022, and we aim to begin the process of review and award at the beginning of 2023. And that does it for my portion of this, and at this time, any questions that you all have for any of us at the chair's discretion are welcome.
Representative Nemus has a question.
Thank you, Mr. Chairman. I also want to thank you for bringing this issue before the General Assembly. It's something we must continue to bird dog. During the conversation, this is a very clinical and legal conversation. I think it's important. A lot of money going on. We're talking about a lot of dollars. I want to thank the attorneys general throughout the country, but especially our own Daniel Cameron, for getting this done. But I want to remind everybody here why we're here and what this has wrought, what those companies and those families have wrought on the state of Kentucky. They have blood on their hands, some from my own family. We have communities that have been absolutely devastated and destroyed, businesses that can't find workers, children who can't find fathers and mothers, grandchildren who are raising their kids. We've got methamphetamine, we've got heroin as a direct consequence to this overprescribing of opioids that our physicians were told were not addictive. We have squalor in Kentucky in many places, especially in the Midwest, because of these companies and because of these families. So I want to thank you for going after them. I see a lot of cases, pending cases. Keep the pedal to the metal, guys, the pedal to the metal. But I want to know why there are no physicians on that board. A number of physicians had hundreds of thousands of dollars in speaking fees, Kentucky physicians. as well as physicians throughout the country, have had hundreds of thousands of dollars in speaking fees and other incentives to push these pills on our people? Why are doctors not being held more accountable? Kentucky Board of Medical Licensure tries to do a good job, but they're hamstrung in a lot of ways. I want to see Kentucky physicians and national physicians on that list. So also, and here's my question, why are they not on there? But also I want to know what are we doing and what can we do to help the attendant consequences? We have obviously a flood of this junk coming in from the border. What can Kentucky do to help our people heal and to stop this? What you've done is good. What more can we do?
Well, thank you, Representative Nemes. I think there are a couple of questions in there as far as why there are no physicians. I mean, first of all, the theories of these lawsuits are effectively in public nuisance by and large, and I think it would take a different legal theory to bring a case against physicians, especially given their licensure and their oversight by the government. It's certainly something that we can look into, and I will take your suggestion back to General Cameron and recommend that we do that. We do work with allied attorneys general across the country, and it's sort of a multi-state effort, and I'll take that to the larger group as well. I will say, plaintiffs' lawyers have been heavily involved in these cases as well, and they haven't brought claims, to my knowledge, against doctors, which suggests to me that maybe those cases are difficult to bring, but we'll certainly look into that.
Or maybe the damages aren't enough, but in order to fill a prescription, there has to be a prescription to be filled.
Understood. As far as what we can do, the statute that you all have passed includes 29 separate categories of abatement. All of these funds are to be spent on abatement. Cities can't, use it to put up a new playground. They can't fix potholes. They have to use it on drug treatment, on rehab, on court-assisted programs, on a whole panoply of things that you all have included in the statute. And I will say that the last of those items is a catch-all to allow for other abatement programs that are not specifically listed. The settlement agreement itself provides for a much larger list of potential abatement programs. You all can see that agreement on our website at ag.ky.gov. And you'll find a link to the opioid settlement, and there in that link you'll find a link to the settlement agreements themselves, one with the distributors and one with Johnson & Johnson. And you'll see that the variety of things that can be done. I think Brian can speak to this as well, but we expect the commission on the state side to dedicate a good bit of its time and effort toward identifying the abatement programs that it believes are most effective, and then to sort of develop priorities so that these funds can be used in the most effective way possible. But I agree with you that it's been a devastating, impact. We saw just this week that overdose deaths have increased 15% year over year from last year, and last year was 50% over 2020. So this has been a devastating problem. You also alluded, Representative Nemes, to the border. There is, I think, good information coming from federal law enforcement agencies to the effect that the Mexican drug cartels are bringing huge quantities of fentanyl and other drugs across the border on a daily basis. And all of those drugs are distributed effectively across the country by the various branches of those cartels, which are operating in every major city, including Louisville and Lexington and every small town across the Commonwealth. So I would certainly recommend that the legislature look to whatever ways it can to enhance law enforcement's ability to bring resources to bear against, these operations. We just, in conjunction with our federal partners, last month, I believe it was, had a raid that busted some of these drug dealers. This was a Cuban gang, believe it or not, in London, in Laurel County, and they seized over $2 million in cash from the shed on this property, and that was all drug money. So it's a huge business. It is a growing business, and my own personal view, again, and I haven't consulted with General Cameron on this, but my personal view based on my involvement in the litigation and what I've read over the last several years suggests that the problem now is being fueled at least as much by illicit drugs coming across the border, which is effectively wide open to the cartels, as it is by the companies themselves. These settlements that have been put in place will impose some serious abatement and injunctive measures on those companies. So they will no longer be able to continue the sorts of business practices that they did unfettered throughout the latter half of the 90s and throughout the 2010s and before this litigation came about. So we are hopeful that the litigation will actually be effective in stopping the abuses on the company level, and then the rest of it is a much larger problem.
Senator McDaniel has a question.
Thank you, Mr. Chairman. I have two, one very micro and one more macro, which is probably a statement. First of all, Vic, you didn't touch at all on Senate Bill 90, the pilot project, $10.5 million a year from the Opioid Settlement Fund. Do you guys have any involvement with that, or do any of you have any thoughts on the progress of that?
I don't know what the specifics of that are. I'm going to turn that over to Blake.
It's my understanding that the commission itself will not play a role specifically in what Senate Bill 90 is intended to do in terms of setting up the diversion program and the housing and assistance program that comes along with it. I do suspect, however, and I'm not on the commission, and maybe Brian can speak to this in more detail, but I do suspect that the commission will take a look at programs or entities that operate in the same kind of space. And certainly to the extent that Senate Bill 90 is funding programs that prove effective, the commission will be, in every reason to piggyback off of that.
Yeah, Brian, in fairness, the commission hasn't met yet, but Brian may have some thoughts on that.
I'm going to try to get two birds with one stone in response to what Representative Nemes raised, as well as the question that you have asked specifically about Senate Bill 90. And as we think about the way in which this commission is going to prioritize its work, please bear in mind that I am just one of 9 and therefore cannot speak for everybody on the panel currently. But as previously observed, this problem has rent the fabric of this state. Every level of its social fabric has been rent by this problem. If we're going to prioritize our work, we got to recognize that as big as the figure of $500 million sounds to the everyday ear, it is a drop in the bucket compared to the catastrophe that has been unleashed here. So what is it that we need to focus on? Number one is to prevent the next generation of addiction by bringing as much normalcy and stability and love to the children of this state as we can deliver, insofar as those children have lived in these homes that have been destroyed by this problem. The next priority is to remove every single barrier we can from the lives of those who have been victimized by addiction, who have shown durable recovery, and making sure that they have a good, clear avenue to acquire and maintain ownership of their lives and their destinies. It is only through that individualized ownership of destiny that an individual is going to be able to maintain sobriety moving forward. And then, thirdly, but not lastly, there's a tremendous amount of innovation in this state. We are home to a number of inventive individuals. We are going to be having open eyes, minds, and ears to whatever model demonstrates the greatest promise of delivering the greatest percentage of durable recovery going forward. There are models that are out there that are in existence that do fairly well. There could very well be others that deliver superior results. Whatever those may be will be considered, and insofar as there are innovators out there who have things that have not been seen but demonstrate measurable results, we welcome them to come and visit with us.
Very well. And then secondly, guys, this will be a longer term, but I do want you to put some thought to this. I think the total amount of the settlement was $24 billion, give or take.
Roughly 24 for abatement, another 1.7 or so for fees.
And the nature of the problem existed over 20 years or so, right? Where the actual illicit activity that we're worried about. Here's where I'm driving with this. For a fraction of that $24 billion, I will build you a magnificent tunnel that's 3 miles long, paved with concrete, reinforced, and you will run through, for God knows how long. Heck, I'll build you 7 or 8 of those tunnels, right? And so you can say whatever you want about the things that we're going to do amongst the, in the marble halls of law, pushing through to trying to help folks. But as long as there is a tremendous financial motivation that exists inside of the drug distribution industry, which is now clearly shifted to the black market, they're going to come, they're going to try to do it. Someone is. They might not be, in corporate offices in New York City or wherever anymore, but they'll come and they'll do it because they value that money over those people's lives. So until we make it so painful in that distribution process, so financially painful, right? Because that's what the folks care about. Until we make it so financially painful to distribute, we're not going to get a handle on it. We'll help some folks along the way. We really, really will. But there'll still be a steady supply of those upon whom they can prey. So I just want you to think about as you develop this plan, what can we do to make it so financially painful for those who exist outside of the current legal construct? And I don't think you can answer that right now, but I think it's something I'm going to want an answer to as we advance. All right?
I appreciate that, Senator.
Senator Wheeler has a question.
This question would kind of follow along with the comments by Representative Nemus and also Senator McDaniel. I mean, why aren't we seeing physicians on this list? I mean, I can think of many physicians long after the problems of opioids became apparent that continued to push this stuff. I mean, in my region alone, there was a Dr. Robert Windsor that agreed to a $20 million consent judgment based upon pain medications and unnecessary treatment and opioids he dumped all over eastern Kentucky. He was flying in on a private jet out of Georgia to like 4 different clinics in Kentucky, having them lined up out the door. I can remember this was going on. They were lined up out the door just dumping this crap on the street. And if you can agree to pay $20 million, you've probably made a hell of a lot more than that. And, to say these people these doctors don't have, have empty pockets, very few of them have ever been criminally prosecuted. I mean, there have been some, no doubt, but those are the exceptions rather than the rule. There was, I think, at some point, a widespread collaboration amongst, a very small minority, but a significant minority of the medical community that collaborated with these drug dealers, drug companies, to push this stuff out onto the street because of the great rewards that they were receiving for doing this. And yet, so very few of them have been made accountable. Criminally, sometimes that's tough. But, in civil court, you only need half plus one. And, it's a much lower standard of proof. And, this goes along with what Senator McDaniel said. As long as the reward is there, people will continue to do it. And I think you're starting to see this sometime with medication-assisted treatment now. These Suboxone clinics that are springing up all over the place, dumping, the next generation of, supposedly it's going to help. It's basically become a street drug that's being sold on the corner just like everything else. And, I know in our community we had one clinic where, these doctors were getting paid in to come in for, 2 weeks a month, $5,000 a week, or no, I think it was $5,000 a day to write prescriptions. And they were being counseled along with their prescription by a guy that had previously been convicted of child molestation. And yet all this was paid for with Medicaid funds. And these people were raking in millions and millions of dollars. And yet very little I have seen out of the prosecutorial systems to really step in and stop this type of abuse, which is creating a whole other generation of zombies walking around on Suboxone. And, you know, I commend you for the work you've done. This is tremendous work, and I don't want to diminish it in any way. These companies needed to be held to account. But there's other people out there that are making, you know, great fortunes off of the misery of others. And we're having to spend great fortunes to bring these people who have, you know, essentially been turned into useless lives to bring them back into something productive in society. And, you know, this is a huge burden not only to the taxpayer, but to the moral fabric of our country. And I really think that, you know, not only do you need to go after these folks on a macro level, and perhaps they're the easiest. They're the big, bad, evil corporations that, you know, dump this stuff with deep pockets, and sure, that to some degree is low-hanging fruit. But, you know, we also have to look at a local level as to who is putting this stuff out on the street in the communities and go after these folks. And I challenge you to do that. But I want to thank you for the work that you've done, and I hope that in the future you'll look to some of these other issues that are arising out of this pandemic.
Thank you, Senator. I certainly appreciate that. And as I said earlier, it's an issue that I think we will certainly look at more closely. We have had some successful criminal prosecutions, especially in the Medicaid fraud area. Brian Hubbard was, until his appointment as director, the head of our Medicaid fraud office, and I don't think anybody's got stronger feelings about the abuse of Suboxone than Brian. Brian, do you have any comments?
Let me address the issue of doctors not on the list, and then I will turn attention to Suboxone. While it is correct that there are no doctors or physician practices on the list of civil suit participants in this slideshow, I wish to assure everybody in this room that there is a list of physicians within the Medicaid fraud office who are the subject of criminal investigation due to the way in which prescription behavior is parlayed into Medicaid fraud. We also have a list of cases that we work jointly with our federal partners in the Department of Justice, U.S. Attorney's Office in both the Eastern and Western District, the FBI, as well as the DEA. The Medicaid office out of the Attorney General's office supplies a tremendous amount of evidentiary ammunition to these high-profile federal cases that you will read about in the paper, though we have no ability to disclose due to their sensitive nature. Having said that, one of the things that hobbles our enforcement ability within the state to prosecute prescribing behavior as part of trafficking is that there is no legal framework with which to do that. I think that some folks in my office would very much like to bring direct prosecution of physicians for their prescribing behavior, but we've got to have the legal authority to do that. Insofar as Senator Wheeler observes the phenomenon of Suboxone, something which, when administered in the clinically appropriate and ethical manner, demonstrates promise when it comes to rehabilitating an individual who has been obliterated by opioid addiction. The reality is that there are a number of bad actors out there engaged in ostensibly rehabilitation medicine when in fact they are glorified drug dealers who do their drug dealing through the respectability of a prescription pad. We have data that shows the proliferation of Suboxone pill prescriptions over the past 5 years, and it is an arresting figure. So this will be something that this commission is going to have to look at very seriously in terms of how we utilize the precious resources given to it to address addiction, and whether or not we need to be looking at the perpetuation of a milder addiction as a cure for addiction itself.
Mr. Chairman, a brief follow-up, if I might.
Briefly.
Brian, you and I have known each other for a long time. Have y'all looked at even maybe talking with the Department for Health and Family Services to maybe work on ratcheting down the reimbursement rates for these types of therapies so that they are not profitable for bad actors to be involved in?
As I took a look at the Suboxone prescribing data, the actual cost of the individual pills has decreased over the past 5 years, so they have become cheaper, which, depending on how you look at the issue, can be a double-edged sword. What we believe is the most imperative area of cooperation is when it comes to running algorithms which show outliers of prescribing behavior and making sure that we have a good handle on those clinicians who are running drug operations rather than rehabilitation clinics. And that probably is the very first and best method that we have right now of identifying individuals who are engaged in bad conduct. Disincentivizing operators of Suboxone clinics who foster addiction rather than cure it is a priority for the office, and that's got to be done with a significant amount of prosecutorial firepower.
Thank you, Mr. Chairman.
Thank you.
Okay, our final question, Representative Tipton.
Thank you, Mr. Chairman. I appreciate you being here today. This is a critical issue. I dare say there's not a single one in this room who either knows someone or knows a family who's been impacted by a drug overdose issue, drug overdose death, and it's something we have to get a handle on. Time is of the essence. Brian, you mentioned that $483 million sounds like a lot of money, but compared to the problem we have, it's minimal. I watched the news show yesterday. They were talking about the issue of drugs, and the individual on the guest made the comment that there's a new drug coming out that's 20 times more powerful than fentanyl. Think about that. This issue is not going away. I'm afraid, unfortunately, it's going to get worse before it gets better. My question really goes to the way these settlement funds are going to be used, half to the state, half to the cities and counties. And I think it's good to have that local import. My question is, and maybe a concern, is what can we do to prevent repetitive type programs or overlapping programs where maybe a city and county is doing something that also a state fund is doing? Do you foresee the ability to work cooperatively with the city and counties and partner with them on how these funds are distributed? Because these are limited funds, and we're making a huge investment. Any thoughts on that?
Making sure that we are not engaged in wasteful repetition will be an absolute priority. We want to make sure that there is as much communication and coordination between the work of the Commission and the work of the counties and cities so that we are delivering focused and linear services, however those are defined. Now, as you might imagine, there's going to be a good amount of cat herding involved in this in terms of trying to keep everybody focused on what the priorities are and assuring that the money is used for its purposes. But we will absolutely do everything that we can to ensure that insofar as there is redundancy, that is purposeful and is intended to be so, rather than just wasteful and repetitious. I would like to make one quick last point on this issue of Suboxone that Senator Wheeler raised. I believe that over time, we're going to be able to demonstrate that pills that are prescribed for folks out in East Kentucky to help them with their addiction not only are being diverted within East Kentucky, but there is a cash conversion process that is making its way to the west end of Louisville. And the prescription drug problem that is in the East is very much tied and linked to the drug problems in Louisville itself, in particular the West End. So insofar as we are able to demonstrate that there are mechanisms or policies in place that are wounding both of these communities, we're going to identify them and specify them and bring them to your attention so that the appropriate action may be taken.
Representative Tipton, real briefly, I want to comment on the redundancy issue. I think there are probably two ways that we can address this. One of them is a government-related approach, and one of them is a non-government-related approach. Representative Nemes before asked what can we be doing in the interim, right? And one of the things that we tell folks is, don't wait for the application process to go live before we start thinking about what those applications are going to look like. So we encourage people right now to start having conversations that go beyond county borders, that go beyond city borders, that go beyond different kinds of silos in the treatment community, right? But to have everybody start talking to figure out what is the biggest, best, most comprehensive way possible that we can attack this problem. And rather than doling out a little bit here and a little bit there, let's do big things. And so I think that's a non-government approach of looking at it. And then from a government perspective, I think, and again, I don't sit on the commission, but I think the commission itself will have an opportunity through its application process and the regulations that it promulgates to address this issue and ask folks, right, in the application process, where else are you getting money from? In what amounts? Is there any repetition, right, to the other places where you're getting money? And be able to see that and review it and consider it before deciding whether or not to fund that application. So.
Well, gentlemen, thank you so much for your testimony, for the work that you're doing for the folks of the Commonwealth. Very important work, and we'll look forward to continuing this conversation in the future, see what this money's able to do in our communities on a micro level and a statewide level. Very important work, and I thank you for the data that you brought today and the comments that you made. So thank you so much. Next on our agenda, we have Senator Givens, who's here in the audience, and he's going to touch on Senate Bill 88 from last session. That's an important piece of legislation that may be very necessary, hopefully, in the next coming session. So, Senator Givens, the floor is yours.
Co-Chair Mills, Co-Chair Miller, and Co-Chair Bratcher, thank you for the chance to be here and share with all of you something that you've heard before, you've voted on, but I need to bring it back onto your radar because of what's going to happen in November as this constitutional amendment proceeds onto the ballot. And I've said in committees, both in the Senate and the House, of my years in the General Assembly, this is likely the most significant piece of legislation I'll ever have had the chance to work on. So my overarching goal in a brief conversation with you today is to place the constitutional amendment regarding our ability, our limited ability to come back into session, place that back in your minds, on your radar as you get ready to travel through the summer, interact with colleagues and voters, and you're going to be encountering questions. My charge, my hopeful charge, is that all of us will be advocates for this legislation. And in support of that, I want to bring back in front of you conversations we've had for the last two sessions about the statutory enabling legislation to provide some framework around that. Because hopefully, if the voters ratify this constitutional amendment, we'll be back in January passing legislation that provides a statutory framework for us to move forward. So I'm going to start with a brief history. I'm going to move through it not rapidly, but at a good pace. And I'd love to have some conversation and dialogue about questions you have. And if any of you here have reservations about being an advocate for the power of the legislative branch as a result of this constitutional amendment, let's have that dialogue now. Let's try to work through it now so that you can wholeheartedly support this as you talk to voters. So the journey of the legislation actually started with House Bill 4, and this was, as many of you know, sponsored by the Speaker. It had 32 co-sponsors in the House. Came to us in the Senate, that constitutional amendment, back in 2021. We made some minor changes. It passed the House in significant numbers. I think that vote was 77-16. It passed the Senate 31-4. Came back to the House after some amending on our side and passed 78-16. That's the language that will be in front of the voters this fall. As that legislation moved through the process, we realized that the Constitution shouldn't and doesn't address all of the concerns that may be around our ability to come back for time-limited special sessions as called by the Speaker and in conjunction with the President. Those two concurrently would call this session. It would be limited to up to 12 days, if you remember the conversations, and we could come back and break that into pieces. Those pieces would not adjourn us, sine die. We would simply continue the session through December 31 of that year. Companion legislation that we had in 2021 was Senate Bill 181. What we had again in 2022 is what you, Chair Mills, permitted me to speak on the agenda about, Senate Bill 88. And again, that's a statutory framework around how do we enact safeguards in statute, certainly a different construct than Constitution itself, but how do we provide safeguards in statute to function and move forward? We would need to address that in January when we come into session if the voters do ratify this, and I'm hopeful that they will. As we prepare to have a conversation about this, and I hope you do have some questions, the thing I've said before, so much of the legislation that we did, especially in light of COVID and concerns about the executive authority and executive power, were prospective pieces of legislation saying, let's put this safeguard in place. We don't know if it needs to be there or not. Oh, suddenly this emergency authority of the governor that we know we need in times of weather emergencies, we don't want overused in other cases. We had to do so many things prospectively with Senate Bill 1, Senate Bill 2, House Bill 1, and House Bill 2 that if we had the ability to come back for limited purposes, I don't think we would have to do, and therefore I believe we could do better legislation in the end. With that, again, my plea to each of you is to be ambassadors for this legislation and the constitutional amendment. And with that, Mr. Chairman, I'm going to pause and would welcome any questions or concerns members may have.
Any questions of the members? Senator Givens, could you just discuss briefly about the life of legislation after session moving forward into these extra days?
Absolutely. So we had a bipartisan group working on the legislation, and we decided that rather than a bill dying at the end of the session, because understand the session doesn't end until December 31, we decided let a bill live on through the year. A lot of legislative bodies do this. Now, a bill still requires the same readings and same number of days as it does previously. But if we were to come back around an issue that a member had filed a piece of legislation on, that legislation would already be in the hopper, be ready for readings and or action. And I think that's very appropriate. The other interesting discussion we had multiple times as the legislation was moving through, both the constitutional amendment and the statutory language, was, Senator Givens, don't you think that the Speaker and the President should be able to limit the call? Because we're inherently involved in this mindset of the executive branch can limit the call. Let me start by saying we don't do anything to change the governor's ability to bring us back into a limited call special session. Separate conversation, not impacted by the constitutional amendment or the statutory changes. But I feel strongly that all of us are equal members of this legislative body, and in no way should, even though we elect a speaker and even though we elect a president, they should have no more authority or power than we do as it relates to the passage of legislation. And so we arrived at a place where we're not going to permit the Speaker or the President to limit a call or focus on an issue. The voters will tell us if we've done it wrong. If we come back and start doing things the voters don't want, we'll hear about it. But I think it's very important that we all maintain the same powers.
Representative Gooch has a question.
Thank you, Senator. As you're aware, generally our long session is 60-day session. Generally is a voting year, and it's a year when every House member is up, and probably half of the Senate, I think. Do you think that by maybe leaving a bill that may happen to be a very controversial bill or whatever open until the very end of the session, conceivably that could be right after the November election, do you think there might be either party that was in control might try to put off something that is really controversial in an election year to wait till after after the election? Just a question.
Excellent question, and we had lots of these fun conversations as we were working on drafting the legislation and the constraints around it. Certainly that possibility would exist, I think. I would propose to you, Representative Gooch, that it would not be used, and if it were to be used, it would have to be very tactfully and artfully done in a way, because understand the governor's still going to sign the legislation or not. He or she, the governor, would have the authority to veto it, number one. Number two, the voters and the recall of the voters, even post-election, I would think. And I understand the idea of a lame duck group that may not have as much to risk, suddenly having the votes and desire. But in addition, understand the risk that the Speaker and the President, we had these conversations, the Speaker and the President have to agree on the call, on issuing the notice to come back into session. Not only do they have to do that, if they do it in a way that ruffles the feathers of enough of us as legislators, we typically turn around and would be electing them back into leadership in just a few weeks, possibly, if you think about that calendar you've laid out. So there's a lot of built-in constraints and protections, I think, that would prevent that sort of abuse. I would hope that sort of abuse.
Representative Heath has a question.
More of a comment than a question. Thank you for bringing the bill. I support the bill. I think most of us would agree that in 2020, after session was over with, and the governor was still in charge, you know, he still had the power to emergency orders. And the folks back home were saying, why aren't y'all doing something? And they were amazed when I said, we don't go back into session until January. We don't have the power to call ourselves back in. And if the governor calls us in, he sets the call. We can only take up what the governor calls us in for. It was quite a lesson for the folks back home to learn that that's how this system worked. And I think they are more than on board with this amendment to give us the power to call ourselves back in. And we had to explain to them that when the Constitution was, I think, written or put in place, no one envisioned a 2-year pandemic. I think everybody was thinking a flood, a hurricane, some kind of natural disaster that would hit and then move on, and you know the emergency powers would come to an end. So I've been doing my part to promote this to the constituents in my district, and I look forward to continuing that conversation.
Thank you for those comments. If I could follow up briefly, Mr. Chairman. March of 2020 was an interesting time, and I had an unusual front seat moment in the midst of that. And I'll share the story with you. I don't think I've ever shared this publicly. COVID hits. We're at the height of an uncertainty. If you can recall back the uncertainty that was swirling at that time, it was the absolute height of uncertainty, not knowing what to do. And President Stivers became sick, and we didn't know if it was COVID or not. And as President Pro Tem, I'm then in that position of helping make decisions to lead the body. And the Speaker and I had multiple conversations, and we drafted a letter together to the governor saying, Governor, let us freeze where we are because we don't know how to write the budget. We don't know where this is headed. We don't know the strain on systems or people or resources. We don't know the legislation we need to be thinking about. Let us pause the session for a period of time, and you agree to call us back for the purposes of finishing our business that we have in process, and we'll move forward. And the answer was no, and he has the authority to say no, but I didn't like the no. I didn't like the no because it put us in a place of having to make decisions without information. It put us in a place of having to rush decisions that were impactful on people and lives. And we would have had the chance, if we had this sort of legislation in place, to have paused it ourselves effectively and moved forward. So I appreciate your support. I hope everyone will support it. And if you have reservations, raise them now or talk with me offline. I'll be glad to try and listen to those. We did not finish passing Senate Bill 88, and so we will have a prospective piece of legislation early in January that all of you can help have input on if the voters ratify this constitutional amendment.
Very good. Any other questions? I'm looking here. Senator Givens, thank you so much for bringing this again. Once again, I think it's a very important issue. That's why we brought it here today, to get it on everybody's agendas again, and to remind them about the constitutional amendment as well. So that concludes our meeting. Our next meeting will be July the 19th. Oh, let me make one comment real quick. Because we've all worked with him, I would like to personally thank Michael Callan. He is actually moving on, And Michael, Michael's back here in the back. He's drafted bills for everybody, and just want to thank him for his work here at the LRC and wish him well in his new endeavors. So with that, we are adjourned.